Welcome back to the morning show here on the Raj News. Well, Senior Advocate of Nigeria, Femi Falana, has said that he will challenge the constitutional validity of allocating oil blocks to individuals and international oil companies if the federal government refuses to accede to his request to stop the Unconstitutional Act. He joins us now from our Abuja studios on the morning show. Good morning, Senior Advocate of Nigeria, Femi Falana. Many thanks for joining us this morning.
Good morning.
Good morning. Thank you very much.
Yes, good to see you, and thank you for coming to the morning show. Let's just go straight to this, your position on the allocation of oil blocks to multinational oil companies and also individuals. You said you prefer states and the federal government to take direct ownership of those, either marginal fields or oil blocks. Do you really think that the federal government or the state governments have any capacity? The same governments that cannot manage refineries, that cannot maintain basic infrastructure? And do you not think that what you are proposing is likely to create other problems of its own in terms of even how that allocation can be done?
Well, my experience, with profound respect, I have clients and friends, in the system who have been allocated oil blocks. And my experience is that these guys simply go to Beijing or London or Paris or New York and rent out or lease out the oil blocks without adding any value, or contributing anything meaningfully to the development of the oil industry in the country. And so for me, if you give those blocks to the federal government or return them to the federal government and the state government, they can now, in alliance with, companies that have capacity, and that is why the federal government has entered into some joint venture agreements with companies, to mine the resources and develop the oil and gas industry. And then the money that is made will go to the federation account or the account of the federal government or the state government. But a situation whereby, I give an oil block to my friend or political party members, and they sell them, rent. That is what we have is, rent collection. Rent collection. And it is better that such rents are collected by the federal and state governments to pay salaries and develop the country, infrastructural development, instead of enriching a few people, who some of them have confessed that they do not know what to do with the money. Haven't rented out, haven't leased out our oil blocks, which, by the way, are the collective property of the country. And I expect that my suggestion will allow us to go back to the drawing table. The National Assembly will have to come in. Because if you look at Section 44, subsection 3 of the Constitution, it does provide that the oil resources of our country, mineral resources of our country, and other natural resources, gas resources, will be taken over by the government, federal government. They shall be vested in the federal government and managed in a way that the National Assembly may deem fit by making a law. But right now, the country is not gaining from these resources. On the contrary, we are promoting dangerous income disparity.
Well, I see
some people are smiling to the banks at the expense of all of us, while the country is getting poorer.
Isn't there a contradiction in all of this? I see the socialist, perspective. I see it clearly. But even if the federal government takes direct ownership, the state governments take direct ownership, do you think the federal government or the state governments have any capacity to be able to even do what you're trying to say, particularly at a time when there is this alienation between the people and the government? What is the guarantee that the long-term objective that you are talking about of ending rent collection can be achieved with the model you are proposing?
The model I'm proposing will make us to sit down and look at the best way to manage the oil blocks. And the point I'm making is this. Right now, those who are allocated the oil blocks are not managing them. They simply rent them out. And that's not beneficial to the country. And the point I'm making, therefore, is right now, the federal government through the NNPC and MPDC manages some oil blocks where the capacity is not there, right? They combine with foreign companies that have the fund or the capacity. But a situation where this is given to individuals is dangerous for the country. Income disparity is causing problems for our country. And we must look at the root cause of our poverty. If individuals are collecting the rents, why are they not being collected by the federal government and the state government? Why should the federal government be taking loans every year to fund the budget, to pay salaries and allowances to public officers? Where you have these assets that are taken by individuals who sell them and they then confess, we are so rich that we don't know what to do with the money.
Okay, if you allow me to come in here, if these allocations are given based on free, fair, and transparent bidding process, wouldn't that suffice the equitable distribution you're talking about? And people are drawing, allusions from the GENCOs, for instance, in the power sectors and the DISCOs. Isn't it the same thing? Well, I mean, if this is given out in a fair bidding process, isn't that sufficing for equitable distribution when the people come together and bid to have these oil blocks?
This has been the excuse over the years since privatization started in 1996, 1986 or thereabout. This has been the argument. Oh, government cannot manage businesses. Let's give them to individuals. Which individuals? With profound respect to those who are contributing their quota in the private sector, most of the assets we have given out have been run down completely by these specialists in the private sector. You take the Nigerian Airways, for instance. All the assets were sold. The company was liquidated. Our country is worse for it. Even some of the private companies that were given out to individuals through this so-called transparent bidding process have been run aground because those who bought simply engaged in asset stripping and mismanagement of those resources to the extent now that the country has not gained anything from such processes. You talk of privatization of the electricity sector. Again, I think Nigerians are wiser for it now. Those who bought them lack the resources, the funding to improve on them. So you still have a situation whereby the government has to provide money after giving them money initially, take off grant. Government has to bring in what you call intervention funds all the time. Today, the AMCON is currently trying to manage over 15,000 companies that took loans from our banks. And when those banks were going to collapse because of toxic loans, again, the federal government has to come in. That is why today you have AMCON, the Asset Management Corporation, which is battling now to recover not less than 5.4 trillion naira from the private sector.
Well, Mr. Falana, the Petroleum Act, I think, creates room for open competitive bidding, even if it at the same time allows the Minister of Petroleum to use discretion. Okay, but two quick questions. One, have you received any response to your letter, the letter you sent to President Buhari on this matter, or do you expect a response?
No.
Two,
no, I just sent it on Friday, but let me correct this. I think I have argued, I have made a point, and I want to be challenged on the legal point that the oil blocks or marginal fees are not part of the asset to be privatized by the country. So you cannot just do what you like under the law. There's no law that allows the allocation of oil blocks to individuals. That's my point. We start from there. I am expecting a reply from my letter. And if it's not favorable, I believe very strongly that this is a matter that will have to be resolved legally. I'm going to court.
Okay, well, thank you for that information. I'll check the Petroleum Act again because I thought it makes room for concessionary allocations. But again, all of this, if the president were to take your suggestion and to stop the allocation and even to stop some of the ones that have been allocated, what are the kinds of contractual issues that may arise from this, and what will be the cost to the country? Because we have joint venture agreements,
Again,
some of which we are not even managing well.
Yeah. No, all those will have to be sorted out. And it's not going to be an indiscriminate action. Where people have invested, of course, you will have to give compensation. I mean, I take a hotel. I won't mention the hotel, for instance. A sitting president and his friends bought one of the most successful hotels in the world. Last year, that hotel raked in a profit of 17 billion naira. There is no country that is run that way anywhere in the world. And you look at the law. You're talking of concessions under the Petroleum Act. That would not take precedence over Section 44 of the Constitution. But as I said, that's why I'm saying we must go back to the drawing table. What is the best arrangement for the interests of our country? But we can't just have a situation where you give oil blocks to people, intervention funds to them, the same people, duty waivers for them, right? Tax holidays for them. You can't run a country like that and promote income, equality. People are getting dangerously rich at the expense of the rest of us, while the country is taking loans from China or from the West, to have basic infrastructure in our country. We can't go on like that. That's my point.
Okay, we'll come back to this issue, but let me bring up another issue that is in the news. The trial of Justice CJN Walter Onogen at the CCT Code of Conduct Tribunal. Now the prosecution has closed its case. It called 3 witnesses instead of the 6 it promised. The defense counsel says that they're making a no-case submission. Now, what do you foresee? What do you think should happen at this point? What do you recommend? What do you think will happen?
Well, frankly speaking, as a senior lawyer, it would be irresponsible on my part to go into the details of a case that is before a properly constituted court or tribunal. Therefore, the defense will have to put its defense across, either through no case submission or by calling witnesses. But I can't go to the details of the case for now.
No, I asked that question specifically because you are on record as having said previously, and we also had guests on this program who have said that maybe at this point, the government should just withdraw the case. Will you consider that a good option?
Do what?
Should withdraw the case. Put an end to it.
Should do what?
To withdraw the case.
No. My position initially was that the case be withdrawn to allow the NJC to examine this matter first. That position was not taken cognizance of by the government or by both parties, and the trial has started. So I haven't seen any basis why the Attorney General should be asked to file a nolle prosequi and discontinue the case at this stage. It doesn't help the Chief Justice as well, who should be afforded the opportunity to challenge the evidence that have been led by the prosecution.
But do you share the popular view that the trial of the CJN is a witch hunt?
No, I don't share that. I mean, and I think it was Lord Denny that made this point, that a judge, what is sought, must not allow even the perception to be created that is a lawbreaker Once a judge is accused of having broken the law, he has a choice to challenge the allegation and clear himself or check out of the system. So I do not believe, I mean, again, I've made this point repeatedly. I'm critical of the government. Now, if I'm accused of duping my client and I'm charged before a properly constituted court, it won't be my defense to say, oh, it's because the government doesn't like my face. Why should the government like my face? My duty is to defend the allegation. So I as a lawyer, I deal with evidence, not with conjecture.
Well, let's move
or
to
assumptions.
Let's move to another issue, because you also issued a statement recently about the elections. In 2015, you challenged the INEC, the then INEC boss, Professor Jega's insistence on militarizing the elections. Fast forward to 2019, you are also asking President Muhammadu Buhari to put a stop to militarizing the electoral process. How does this make you feel? And what does it say about Nigeria's commitment to democratic process?
Well, it is unfortunate that after 20 years of civilian rule or democratic rule, we are still involving armed soldiers in the conduct of election. And I think it's important for Nigerians to know where we are coming from. Many people lost their lives. Many were detained illegally. Many went on exile. You know, many were jailed in order to send the military packing so that we can have democratic rule in our country. And it will interest you to know that throughout the 30 years, almost 30 years of military rule, on no occasion was the military involved in the conduct of elections. Security was provided by police personnel and other, paramilitary forces. To now have a situation where soldiers will be present or take over collation centers, as has been reported in one state, clearly we're in trouble. And my position is this: we must go back to the law. Based on our experience in Ekiti in 2014, during the governorship election, whereby the PDP was alleged to have used soldiers for that election, the same military, under the leadership of the current Chief of General Staff, General Buratai, set up a panel of inquiry, and all the military officers and soldiers that were indicted were dismissed or retired from the military. They were flushed out of the military. Now, to go back now, 4 years or 5 years later, to be told that soldiers are involved in the election again, there are problems. In 2015, based on our experience between 2003 and 2014, I mean, in those days of do or die elections, the National Assembly amended the Electoral Act to the extent that Section 29 of the Electoral Act 2010 as amended provides that INEC shall be in charge of deployment of security forces during election, provided that the armed forces, members of the armed forces, will only be involved in the movement and transportation of electoral materials, not in maintaining law and order. That is the business of the police.
Well, I mean, during the supplementary elections on March 23rd, the soldiers, the military stepped back, and we didn't quite see them playing a frontline role during the elections. But the conduct of the supplementary elections turned out to be messier than what we had previously. And there are some people who have said, look, maybe the military should have been there. Maybe it would have been better, particularly with the kind of situation we had in Kano, with the outbreak of violence and open display of brazen thuggery.
with or without soldiers. I mean, let me make the point. As far as the Constitution is concerned, Section 217,
Section 4.
the military can only be invited to assist the civil authority, that is the police, with respect to maintenance of law and order. You don't have the soldiers, you know, taking over or usurping the powers of the police. It is when the police cannot manage a situation that you bring in the military. And that did not arise in Kano or anywhere. What you simply have was a situation whereby there was compromise, alleged compromise on the part of some of the security forces that allowed thugs to take over the system. And that happened even with the previous governorship election. The bottom line is that once you operate in an atmosphere of impunity, there's no way you are going to get it right. In other climes, all those who were caught with snatching ballot boxes, setting fire on INEC offices, or destroying card reader machines will have been charged before appropriate courts, either the following day or a few days thereafter, because some of them were actually caught in the act. But if care is not taken, nobody will be prosecuted, and at the end of the day, thuggery and violence in our elections will continue. So the media will have to help us here. We have exposed the malfeasance that characterize some of the elections. Where do we go from there? Over 2,000 arrests have been made by the police. The media and other democratic forces in our country should now go to the next stage by demanding accountability. All those who have been arrested should be prosecuted in order to check this reckless manipulation of the electoral system that has continued to expose our country to ridicule before the Committee of Nations.
Well, let me ask you a question about the political parties. Recently, you talked about the mockery of the multi-party system. Apparently, you are not comfortable with the fact that we have 91 political parties, and you were asking INEC to take a look at Section 224 and Section 225 of the Constitution and then apply the rules accordingly and reduce the number of political parties. But would this not conflict more or less with the freedom of association? Should we not have as many parties as possible? The more, the merrier?
No, I'm all for multi-party democracy. I wasn't calling for a reduction in the number of parties for the sake of it. I was actually analyzing the amendment of the Constitution, quietly done to deregister political parties that failed to win elections. And I was pointing out the danger that if you reduce political parties to winning elections in hostile environment, as you have just witnessed, and whereby those who had no thugs, those who have not engaged in the primitive accumulation of wealth, or who have had no access to state funds, I mean, could not have won election in the 2019 election. If you now say on that basis you are going to ban their political parties, even if they have genuine program that can lead our country from poverty to prosperity, move the country from poverty to prosperity, there will be problems there. What I was therefore advocating is that INEC has to look at the guidelines for registering political parties, look at the provisions of the Constitution, and ensure that we have ideologically based political parties. And that's my position. You can't set up a political party as a family affair, or you set up a political party to endorse for the purpose of collecting money and endorsing other candidates. No, that is not what a political party is about. A political party should be identified with certain programs manifesto that can add value to governance in a country. That's my position.
Okay, Senior Advocate of Nigeria, let me just quickly take you back to your Oil Blocs statement and get your reaction to this, because indeed there have been lots of reactions to it. What do you have to say to those who argue that your position may just be as faulty as the system you're criticizing, because they say, you know, the people from which those oil fields were wrestled by the military, you know, still claim and maintain that they are the rightful owners of those land and should be the sole beneficiaries of the proceeds. But you're advocating it should go to the federal government and the state government.
No, the Constitution has already taken over those resources from the oil-producing states and vested them in the federal government. As far as I'm concerned, and that was one of the reasons why I've always believed that we should pass the petroleum industry bill to provide for the oil-producing communities. I'm for that. But it's difficult to return them absolutely to the oil-producing communities, but they must have a stake in the management of the resources so that you can develop those areas that are currently undergoing the worst form of environmental degradation. That's my position.
And finally, back to elections. Like you rightly said, a lot of people say, you know, INEC was clearly not in charge of security situation for the elections, which it should have been. But they also say, you know, there has been a deafening silence from the CNC himself concerning the conduct of security personnel in these elections. Are you surprised? Do you think that the CNC should take charge and make statements and take actions at this point?
No. Again, we must try to get things right. I mean, we are not in a democratic environment. We must not give room for dictatorship in any shape or form. The Constitution has been crafted in such a way to allow independence for the electoral body. The electoral body is autonomous, it's independent of the presidency. In fact, Section 160 of the Constitution has specifically provided that INEC shall not take any directive, any instruction from the president, specifically provided. Because in the past, a president once ordered certain ranks to come to Abuja to announce results of election, when the atmosphere on ground in some of those states made it impossible to manipulate and announce false figures of false election results. Now, the National Assembly in its wisdom and all the houses of assembly in the country agreed that there must be an end to such interference, and Section 160 was amended to stop the president of the country from interfering in the affairs of INEC. And we should keep it so. What we should therefore do now, having identified cases of electoral malfeasance, we should now make a point. In order to have deterrence, we must now proceed to prosecute all those who have been arrested for committing grave electoral offenses. For me, that is the best way to go.
Well, thank you very much, Mr. Femi Falana SAN. It's been a great delight having this conversation with you. Thank you very much for always honoring our invitation.
Thank you very much. My pleasure.
Thank you.
Well, it's now time for a short break on the Morning Show. When we return, we'll have Arise News analyst Emmanuel Efeni join us with a review of the top stories on today's newspapers. Stay with us.